Hi, I'm Seth from Hansard Legal, and I want to talk with you today about a couple of options that we frequently end up discussing with people who are either looking to expand their businesses in the United States or who already have businesses in the United States and are looking to come here in order to grow them more effectively. And these options are the E2 visa and the L1 visa, particularly the L1 new office petitions. The differences between these are numerous, and so it's usually a question of what the person's priorities are in determining which one is more desirable for one person or another. Let's get into a few of the details. So to start with the L1, we are looking specifically today at the L1 new office petition. The difficulty with the L1 new office petition is that we're trying to prove in advance what a newly established business is going to be doing within a year. USCIS can tend to push back pretty heavily on that. And so we like to look at this as a possibility, but we also want to be very realistic about what the business is going to be able to document now in terms of their future plans. So what are the requirements that we need to meet for this category? Well, we need to show that there's an existing business outside the United States where our applicant has been working as an executive or a manager, or in some area where their knowledge about the business or about the area of work is essential to the function of the business. If we have that qualified applicant and we have a business with a qualifying presence in the United States, launching either a new subsidiary or a new sister company to an existing company outside the United States, then we're going to be able to look at and at least consider the L1 new office petition. Once we've established that at least those basic requirements are met, the next step is to say, okay, in real practice, what are the next 12 months of this new office's life going to look like? Do we have a clear business plan, and are we able to indicate specific steps, maybe even specific contracts that have already been signed to start making steps toward generating profit? And will there be sufficient inflow of funds to support the salary that we're saying we're going to pay this manager? Will there be sufficient staff needs for there to actually be someone functioning as the executive or the manager that we're saying we're going to have? If not, this may not be the best option, and in my practice, I generally put a thumb on the scale against an L1 new office application, and there's always going to be more scrutiny when we're telling USCIS what we plan to do versus when we have a proven track record of what we've already done as a business. For that reason, in some cases, it's a realistic option to have an entity established ahead of time, have staff running the business, have people already in place in a managerial role of some sort before we try to bring either a business owner or an executive from overseas to work in this business. Try to establish that proven track record and get the business either past the 1-year mark or very close to the 1-year mark with strong indicators that they're going to continue to grow. But for a business who is able to be that specific, that detailed about their plan for establishing a business and how the business will operate in its first year and how it will grow by its second year, then an L1 new office petition can be a realistic option, and it's not a bad thing. The reason why someone who's a business owner or has an ownership interest in a business will consider an L1 new office petition over other categories is because the L1 is a non-immigrant visa. That is to say, it is temporary, but it has an analog or a very similar set of requirements that can be shown to qualify for an immigrant visa, meaning there's a direct path for many people from the L1 to permanent resident status. That's a desirable thing to have a clear path for and a direct vision for. And so for that reason, it can often be worth the extra work up front to build that groundwork and establish a future permanent resident status for the employee, the business owner, the executive or manager, and their families, spouse, minor children, to become permanent residents and eventually citizens in the United States, if that's their long-term goal. But if that's not the priority, then it might often be more efficient for someone to look at the E2 visa. The E2 visa has a couple of considerations that have to be taken into account. One is there has to be an existing treaty between the country of citizenship for our applicant and the United States. If there's not already an existing treaty, then we don't usually consider this as an option because we can't force the United States and the home country to enter a new treaty. But if there is an existing treaty, which the U.S. has with many countries that have strong economic ties to the United States, then the E2 is often a realistic option for someone looking to start a new business in the United States. There is a requirement for a substantial investment, although there's not a specific amount required. As a rule of thumb, we'll often at least look to see if the person has at least $100,000 that they're able to invest in a new business in the United States. For many people starting new businesses in the United States, the upfront investment is naturally going to reach that mark anyway, and so may not be a major hurdle for some people. For others, it is a more significant hurdle to clear. But if we can clear that hurdle, if we can show that there is a substantial investment to be made and where the funds are coming from and that they are legitimately gotten funds, then it can be a realistic option for someone looking to start a business. It is a quicker application process than what we see with many L1 visa petitions, especially for new offices. The exception there is when we filed the L1 using premium processing. But the E2 is generally a tolerable wait time with a U.S. consulate abroad. Many consulates will have a dedicated unit to evaluate E1 and E2 visa applications, and so those can move fairly quickly. There is an interview requirement that will evaluate both the eligibility of the business that's being launched and the eligibility of the applicant who's applying, looking at their immigration history, criminal history, and so forth, as you see with any visa category. Once that's done, the person is issued a visa to the United States for a period that's determined by treaty. And so for some countries, it's going to be a couple of years. For some countries, it's going to be 5 or 6 years. For Canadians, that application process can be done directly at a port of entry, which is a nice touch. Once that interview process is done, the applicant will be issued a visa that is valid for 2 years or more, depending on the treaty that the United States has with their country of citizenship. Once the person enters the United States, they will be expected to comply with anything that they have shown regarding how they are going to use their invested funds. They will have been, as part of the interview process, expected to explain exactly how funds will be invested and show commitment of funds already for their investment. So things should already be well in motion by the time the person gets to the United States. Not a lot of new things to figure out in running the business at that point. The downside to this visa category tends to be that it's strictly non-immigrant. That is to say, each time I apply for an E2 visa, I am expected to show that I will be departing the United States, or at least expected to express my intent to depart the United States when my visa expires. With that said, there's no prohibition or no rule against applying for a renewal of that visa multiple times. And so there's no restriction on how many times it can be renewed. And we will see people in the United States, often for 20 years or more, renewing these temporary visas. One factor about the E2 that makes it much easier to grow a business in many cases is the business owner, once they've secured their E2 visa, can apply for employees to come from the treaty country, that is their country of citizenship, and work in the business in E2 status. So then there is not just an employer, but also one or more employees in the United States from the treaty country in the same status, E2. That's a plus that many people like, but what we've talked about already tend to be the deciding factors more than the option for employees in between the E2 and the L1. Often it's the immigrant versus non-immigrant options that are available through either one, and often the investment in startup and the amount of documentation required to actually get the visa. These are usually only 2 options that are available to people out of many. If someone is qualified for one or the other, there may be others available. If someone is trying to choose between these 2 options, there are often going to be other things that they can and should consider in terms of immigration options. So if you're trying to make a decision between these 2 and would like additional ideas or would like to just talk about your circumstances and see what might work best for your company, please give me a call. Thanks very much.